Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the Fair Use Doctrine as defined by 17 USC 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.
presiding.
And we're gonna go back on the record in 2210260 FC, people versus Schurr, and all parties are present. And is there anything we need to address on behalf of the people before the jurors come in?
No, Your Honor.
For defense?
Your Honor, we did file motions. I don't think this is now the time to argue them, but we want to make sure the court has received them. And if the court wants any additional argument on the motions, they'd like the court to let us know. Otherwise, we're going to rest on our motions themselves, and we're not requesting oral argument on those.
Okay. And I know there was a question that I did not place on the record that we discussed briefly that I should put the question on the record, and those were jury questions that were not asked. And I believe specifically when the defendant was testifying, and I'm just trying to find that particular question. But aside from that, once I locate that, then I'll read it on the, place it on the record, because I do believe that questions that were not asked should be placed on the record, so, what I'll do is just have it, is the witness ready to retake the stand?
Yes, Your Honor.
And would either side like him sworn in again?
No, Your Honor.
Reminder's fine, Your Honor.
And so you can retake the stand, and I'll remind you, sir, that you are still under oath.
Thank you,
on
ma'am.
Friday.
Yes, ma'am.
And we'll have the jurors come in. Welcome back. You may be seated. And once again, I'm glad to see all of you made it back. Mr. Becker, you may continue with your cross-examination.
Thank you, Your Honor. Like I said, not a whole lot of additional questions, but I do want to get at a few things. One of the things you talked about, though, on your direct exam is that you have kind of a network of experts you rely on, because I think one of the questions was Mr. Stoughton or Professor Stoughton and Mr. Bloomfield were not part of your network. Is that a fair statement?
Yes, sir.
Now, when terms of, obviously you get hired as an expert, you're retained to provide testimony, correct?
Yes, sir.
When you give a defendant access to the expert, do you get compensated for that as well?
No,
Is it
sir.
on top of, you get paid for this, do you get paid for?
No.
Giving them access to these other experts?
No, we don't charge a referral fee in our process, no.
But Mr. Bartel would be part of your network, if you will.
Yes, we would reach out to Mr. Bartel if his CV supported the need, yes.
And Mr. Blake would be part of your network as well.
I don't know that we've ever used Mr. Blake, but I would certainly consider his CV if we needed it, yes.
What about Dr. Kroll? Is Dr. Kroll part of your network?
Dr. Kroll is, yes.
Okay. So in terms of, in this case, did you facilitate, did you reach out to them to say, hey, I got a case for you, kind of?
No.
Okay. But that you provided that information to the defense so they could reach out for this case?
I don't know, I think they had already found them in this case. I don't know that I actually referred them in this particular case.
We talked a little bit about the International Chiefs of Police and the foot pursuit policy.
Yes, sir.
And then, like you said, it's not mandatory, it's adopted, correct?
Right, just to be clear, the foot pursuit considerations paper, I couldn't find an IACP foot pursuit model policy. What I saw was the second resource, which is a considerations paper, but I think that's what you referred to.
But in that considerations paper, they talk about foot pursuits are inherently dangerous, right?
They are, yes.
Do you disagree with that?
No.
One of the things they said, decision to pursue a fleeing suspect should not be regarded as required or even prudent in all circumstances. Do you disagree with that?
I do not disagree with that.
It all depends on the seriousness of the offense, the totality of the circumstances. That's what they talk about, correct?
Yes, sir.
And in terms of, people flee the police for all kinds of reasons, right?
They do.
Some people flee because they curfew violation to a serious felony offense, right?
Yes, sir.
And one of the things, I think it was Eric Heim, the podcast you talked about. Do you recall talking about sometimes innocent people are the most difficult people to deal with because they know you're innocent, you're still trying to figure that out, right?
Yes.
So when you're looking at a chase, it's based on the totality of the circumstance. You would never recommend a single officer chasing 4 armed suspects down an dark alley, would you?
Well, if you're talking about the 2 different types of chases, I think we may have discussed chase to pursue or chase to contain or chase to capture. It wouldn't be unusual to chase 4 people. It might be unusual to try to capture them all simultaneously.
So chase to contain is part of the thing. You keep an eye on subjects and call them for backup and trying to get, establish a perimeter, right?
Yes.
All right. We've talked about it, I don't know if you were here, but just the CLIA, just for the record, Commission on Accreditation for Law Enforcement Agencies. You're familiar with that?
I am, yes, sir.
And that's kind of we've heard it, that's the gold standard, if you will.
That's their marketing slogan. I don't know that they're considered the gold standard universally. There's many organizations that do what they do, but I think their marketing slogan is they're the gold standard, yes.
Okay. And it's all, I think we heard that only like 5% of law enforcement agencies ballpark are CLIA accredited.
Yeah, I don't know the percentage.
Okay. But Grand Rapids is CLIA accredited.
They are, yes.
And you're not faulting, I mean, it's a good thing to have accreditation, right?
Yes.
And one of the things that CLIA does is they take a look at comprehensive and uniform written directives that clearly define authority, performance, and responsibilities. That's one of the criteria CLIA uses when they look at a department, right?
Okay, I'm sorry, I did miss that. We say that again.
They look at, is there a comprehensive and uniform written directives that clearly define authority, performance, and responsibilities? That's one of the criteria.
I don't know the CLIAs in front of me. I would take your word for it if that's one of their written criteria, yes.
And part of how they do that, though, is they bring in people from departments from all across the country, right? To look at the policies of a specific department.
I don't know that that's their policy, no,
You don't
or
know how
process.
it's done? You don't know the process of CLIA?
I know the process of CLIA, the evaluation model, sometimes just a couple of people that have been hired by CLIA, and they would be regional representatives, so I don't know how many or where they get. Typically, I know of one regional representative that will work with the agency. You've listed I think your broader question is, do they pull in people from across the country? I don't know that they do
You don't
that.
know that. Okay. But part of the policy that you cite, though, the policy that's taken policy basis, the reasonable of any use of force is ordinarily judged on the totality of the circumstances, i.e. based on all of the circumstances. That's clearly Grand Rapids policy.
Correct, yes.
Thank you. I have nothing further, Your Honor.
Thank you.
Morning, Mr. Clean.
Good morning.
On Friday, you were asked some questions about who Force Science has consulted with in this case. And you previously testified you consulted with defendants, students, community members, and prosecutors. Has the prosecutor's office in this case ever consulted with Force Science?
Yes.
And are you aware of whether the Michigan State Police investigators that are involved in this case has ever attended a forced science course.
Yes.
Do you recall when approximately we retained forced science?
I believe ultimately it was September of 2022.
Have you ever met with or talked with Officer Schurr about this case?
No,
Did you have any part in preparing Officer Schurr for his statement?
no.
Thank you.
Just one question, we never consulted with you on this case.
Not on this case, no.
There's been years in the past.
Yes,
Not this case.
I think there was maybe just 2 in the past, 2017 timeframe.
Thank you, I remember for that.
Nothing further, Your Honor.
We see a couple of questions on the agenda, so I'll have my clerk grab those for you. To clarify, your opinion is based from you looking at everything, videos, audio, reports, autopsy, testimonial, and then human factors, or the other way around?
So we would start with the first. So we would look at the facts of the case, the evidence in the case that was available at the time. So that would be the videos, that would be the audio. And then when we're taking that and we're trying to evaluate the officer's decision-making and performance, that's when we consider the human performance aspects.
And next, when you got drive stunned in your head, how long approximately did it take to recuperate?
Well, once I realized that I was okay, it was probably less than 30 seconds. I think the initial shock of it probably took more time than the recovery did.
And then next, if the subject didn't have full control of the taser during the time deadly force was used, would you still consider it a reasonable action? Or is this what makes it reasonable?
Yeah, it's again, the standard I'm using is, could a person in the officer's position, knowing what they knew, reasonably believe? And so we don't look at actual threat, we look at apparent threat based on the available information to the officer. So if we later learned that if the officer reasonably believed he had full control, and later learned that he didn't because we could watch a video or do a still shot, we analyze the case based on the apparent threat from the perception of the officer at the time, not what we would later learn. Yeah, I'll just stop there. I think that answered it.
Any follow-up from that, Ms. Hamilton?
No, Your Honor.
And I don't see any other hands raised from the jury. May this witness be excused? Ms. Hamilton?
Yes, Your Honor.
Any objections?
And no objection, Your Honor.
Thank you very much, sir. You are excused.
Thank you, ma'am.
And defense, you may call your next witness.
The defense rests, Your Honor.
And Mr. Becker, are you prepared to put on any rebuttal evidence?
We do have one brief rebuttal witness, Your Honor.
Okay, you may call that witness.
Call Detective Dupree again.
And since you were sworn previously, I'm not going to have you re-sworn, but I am going to remind you that you are still under oath.
Yes, Your Honor.
Thank you. Whenever you're ready.
Detective, kind of going through, I want to get into one of the things you do is you, obviously, you try and get a statement from the defendant in any cases like this, correct?
Yes, I do.
Let the record reflect that I'm showing opposing counsel exhibits 37, 38, these exhibits. Detective, I'm going to show you what has been marked as exhibit 37 for identification purposes. Can you tell the jury what that is?
I'm sorry to interrupt, but 37's already been admitted.
I'm sorry, I thought we had 36.
37 was already admitted.
Okay, then I got to go 38, 38, and 39.
And 37 was training record slash outline. My notes, what it was.
Okay, so let's try exhibit 38. Can you tell the jury what this is?
Yep, this is a typed written statement. It's 3 pages long. It's signed by Chris Schurr on April 15, 2022.
And how did you get this statement?
I requested through his defense. I believe Mr. Dodge facilitated getting this to my office.
Okay, and what you do is after you get this, you turn it over to our office as make it part of the case file, correct?
Yep, this becomes a part of my report.
And I'm going to show you exhibit 39. Could you tell the jury what this is?
Yep, after that original statement, I, along with my colleagues, had a couple of follow-up questions. I numbered those out. I believe it was 13 specific follow-up questions. Purely voluntary, but I reached back out to Mr. Dodge and I asked if Officer Schurr would be willing to answer these follow-up questions, which he did. So this is, again, typed answers to those questions, signed by Chris Schurr on May 13 of 2022. It's 3 pages.
And once again, you made those part of the file as well.
Yes, I did.
I move the admission appeals exhibits 38 and 39.
Any objection?
No, Your Honor.
Right, 38 and 39 are now admitted.
And just to be clear, you didn't, there was not during the interview, this was just typed
Correct.
at some point in time away from you.
Yes.
Just one follow-up thing. Why is the state police investigating? This happened in the city of Grand Rapids. Why is the state police on this?
Yeah, we have a formal agreement with the Grand Rapids Police Department. Again, I work for the Michigan State Police. And before my time and above my rank, a formal agreement was made with the PD that if they had an officer-involved shooting, that our department goes and investigates those. So really, I was there on invitation based on a formal agreement that was in place ahead of time.
Thank you. I have nothing further.
Morning, Detective.
Morning, sir.
I just want to ask you some questions about the statement that was just admitted and the circumstances under which they were admitted, under which you obtained them. You touched briefly on this. Now, this was obviously a case that drew a lot of attention from the public. Is that fair?
Yes, it is.
Okay. And you were among several detectives that were working on this case?
Yes.
Okay. And you recognize that Christopher Schurr was under no obligation to give a statement, right?
No, this is purely voluntary.
Okay. And if you, in a normal case, went out to talk to somebody and said, we would like to talk to you, if they said, we don't want to talk to you, then you can't force them to talk to you, right?
No, and that carries no weight with me, the response.
Okay, but you were doing this investigation, there's a lot going on, and you wanted to hear from him, and you reached out to his attorneys, right?
Yes, I did.
Okay. And by that point, he had Mr. Dodge as counsel, right?
Yes.
And I think you said that the first statement was in April 15th of 2022.
Yes.
And that's something that was signed by the defendant.
Yes.
But came through his attorneys.
Yes, it was.
Okay. That's not an interview you had with him shortly after the incident or anything like that?
No, there was no interview.
And in a case like this where there's a shooting, you actually give the officer some time to reflect anyway, right? Before you would try to interview them, right?
That's standard, that's typical.
Okay. So you don't pounce on them like right after the shooting and start asking them questions, right?
If they wanted to, I would not say no, but I've not had that experience with an officer before.
Okay. And then you got the statement, you asked some follow-up questions, and you actually wrote questions on the second statement that's dated May 13th. Is that fair?
Yes.
And again, it came through counsel, and to the best of their ability, you believe that you got some answers to the questions you had?
Yes.
Okay. But that's not everything that you might have wanted to ask Officer Schurr, right?
No, sometimes when I'm interviewing somebody, those interviews can go on for hours and hours and hours. This was, if I had to ask some pointing questions, it was a short list.
Okay. And so I think it's 13 questions. That's pales in comparison to the number of questions that he could be asked on, say, like cross-examination, right?
Yes.
Okay, thank you.
No, Your Honor.
I don't see any hands raised on the jury. Step down again.
You may, Your Honor.
Any objection?
No, Your Honor.
Thank you very much. You may step down. Any addition?
No additional rebuttal, Your Honor.
All right, so I would like to take a break because looks like the evidence is complete, but we need to go over some things outside of your presence prior to closing arguments. And so I'm gonna ask you to go into the back and we'll take a 15-minute break right now. And meanwhile, even though all the evidence is finished, you're not deliberating yet, so I'm gonna ask you to still keep your notes and not discuss the case amongst yourselves or with anyone else, and also continue to refrain from any new reports in the media and social media, and then we'll see you back in about 15 minutes. Okay? You may be seated. Did my law clerk provide you with a set of the final instructions?
Yes, sir.
Yes, sir.
On a Friday. And we sent over some proposed additions and changes.
I would like to take a break and go in the back to discuss anything that you can discuss as far as hashing out the instruction. I also noted that on the expert witness instruction 5.10, there's several experts that are missing and some that their expertise is misstated. So I'm correcting that particular instruction. But if you want to come in the back and make sure that they're complete, and if there's any objections, we can deal with that when we come back on the record.
Okay, so are you saying that we don't have the final instructions yet?
I'm saying, my law clerk provided you with the final instructions. I noted that there's some things that need to be inserted. I don't have the, Ms. Hamilton mentioned that that you sent something over, I don't know if there were corrections or objections. Either way, I haven't seen those. If they were sent over the weekend or this morning, I have not seen those. So I would like the opportunity to review those before saying these are the absolute final set of instructions.
Okay, Your Honor.
Okay? And then I did note that there were a couple that were missing, so, but I would like the opportunity to address any additions and that sort of thing without having it along, dragged out discussion on record about them. But if you don't want to, that's fine. I just thought it would,
Whatever the court prefers.
I just thought it would be easier.
Just one thing here, you didn't ask at least one question, you want to put that on the record before we forget?
Thank you for reminding me about that. So I did want to put the questions that were presented by the jury but not asked of the defendant, and then this particular witness that just stepped down, there were two questions that were not asked of him. As far as the defendant, there was a question by one of the jurors that we did not ask him, which is, and that's after discussing at a sidebar, and that is, has your wife ever asked you to get something from a different area of your house? When you don't find it, does she take your word for it, or does she go check herself? It was not asked. Also, did you speak to anyone about the incident between April 2nd and when the statement was submitted? That was not asked. And also not asked is, did anyone offer their suggestions or advice on how to write the statement? So those were questions that were not asked of the defendant because they were found not to be appropriate to do so. And then of this particular witness, there were two questions that were not asked. The first is, can you explain your thought on bodycam from Becker's reference? That was not asked. And then, have you ever testified in a case for the prosecution where the police officer was found guilty? If so, how many? That was also not asked. And I believe those are all the questions that needed to be placed on the record that were from the jury, not asked, but needed to still be placed on the record. I do have all of the jury questions, and I've noted with an X the ones that were not asked, and a check mark the ones that were. So that will be part of the file. And is there anything else before we recess briefly to go over these instructions?
Nothing to add. No, Your Honor.
So, we'll recess briefly for that happens.
All right, please.
Becker for the people.
Support giving this lesser included instruction to the jury. Other than that, we support the instructions as intended to be given by the court.
All right, and for defense, Ms. Hamilton, and that was Ms. Blodgett for the record, sorry. But go ahead.
Thank you, Your Honor. I know we've talked briefly about this in chambers. We have also filed several motions on the jury instructions since the end of February, so there's just a few things, outstanding things that we would like to put on the record. The first thing is our motion to exclude voluntary manslaughter, which we understand that the court denied that motion, but that motion was filed this morning, as we do not believe that malice is an element that is in dispute in this case. And the only issue for the jury to decide is the justification. However, we understand the court will be denying that motion. And then we also have filed
Giving me all of them and then potentially missing one on the record. So as far as the voluntary manslaughter as a lesser included offense, I am denying the motion to exclude that. I do believe it to be a typical lesser included offense for any second degree or frankly, open murder, first degree murder. It's voluntary manslaughter is a lesser included offense, so I am going to, or I have overruled that particular objection. So go ahead with the next one.
Thank you, Your Honor. The next instruction that I would like to put on the record is the use of deadly force in self-defense. And this, we have had a standing objection to this, but I don't think it's ever formally been placed on the record. We are objecting to the standard self-defense instruction being applied here because we believe that police officers have different duties and requirements under the law, and we do not believe that the standard self-defense instruction adequately addresses those issues as laid out both in the Court of Appeals and case law that we have laid out in several motions that we filed on this issue. So we still would object to the standard self-defense instruction and have proposed several other versions of that that we think would more adequately address the position of Officer Schurr.
Okay. And as you know, we have discussed this. Not only have many motions been filed, but we've also had meetings in chambers and in my conference room regarding specifically this particular instruction as well as a couple of other ones. And I'm not giving the standard instruction, I'm giving the one that I redrafted based in part on the facts in this case, the fact that the defendant was a police officer at the time of this incident. So I'm not giving the standard. I am going to add in the things that we discussed as far as when a police officer is justified, unlike a private citizen. And I do intend to give the instruction as changed to reflect that. So I do agree with you that the standard use of deadly force in self-defense instruction would not be appropriate under these circumstances.
And yes, Your Honor, just to clarify, this instruction that we have is a combination of the the standard 7.15 Michigan criminal jury instruction, use of deadly force in self-defense, and also the non-standard 13.10, which were combined in this. And then through the discussions with counsel and in chambers, it does include those two instructions combined as well.
All right. Okay. And any other objections to the final instructions?
We have a few others that we just want to put on the record.
Okay.
And we'd like to move to have the use of force to apprehend a felon as part of the record. We've discussed and requested that the court does not provide this instruction as we will not be asserting that defense. We just haven't put that on the record yet.
Okay, so you want the instruction that I'm not giving to be on the record?
I just want to know that we're,
Yes, we would like it on the
Okay.
record, just so.
And so, but you're not asserting this particular defense.
correct.
Okay, so I will read it into the record, this instruction that I'm not giving, which is use of force to apprehend a fleeing felon. A police officer seeking to prevent a felon's escape must exercise reasonable care to prevent the escape without doing personal violence, and killing the felon is justified if necessary to prevent his escape. It is for you to determine from the evidence in this case the existence or absence of the necessity. The police officer must have had a reasonable belief a felony had been committed and a reasonable belief the person against whom deadly force was used was the person who committed the felony. Reasonable is that which an ordinary, prudent, and intelligent person with the knowledge and in the situation of the officer would have deemed necessary under the circumstances. That's the instruction that I'm not giving, and that I believe was one drafted by the court pursuant to various findings by the Michigan Supreme Court and Court of Appeals, as well as the U.S. Supreme Court, to craft that particular instruction. But it's not requested. But it's on the record now. And any others?
Thank you, Your Honor. Sorry, I'll try to speed this along. Two more.
Okay.
The next one is the instruction proposed, the 5.10 expert witness.
Mhm.
And the defense would still be requesting the proposed language that says this to be added to the standard instruction. You should also only consider options that are based on the knowledge and the situation of the arresting officer. Do not consider opinions or testimony based on information not known to Officer Schurr at the time of the incident. To the extent you find that an expert's opinion is based on facts unknown to Officer Schurr at the time of the arrest, you must disregard them and give them no weight. We are requesting that instruction based on the evidence presented by the people's experts that are not based on Michigan law or what Officer Schurr was trained.
Okay. And Ms. Blodgett, would you like to be heard on that objection?
Yes, Your Honor, I believe based on this court's prior rulings on motions on this topic, the people would just assert that the standard expert witness language for the instruction be given.
Okay. And I'm denying that request, or I have denied that request to add that to the expert witness instruction for various reasons. One, I believe the standard instruction to be sufficient. Two, there's several things that these experts testified to that would not be in the defendant's wheelhouse or known to the officer at the time of the offense. For example, the video analysis expert. Well, that's facts that are not known that he used to formulate his opinion because he's an expert in that area. Also, Dr. Cole, for example, he's a forensic pathologist. He gave an opinion that does not include facts known at the time of this incident to the officer. So for those reasons, I believe that the instruction, the standard instruction as written is sufficient, and I'm going to give it as written and not add any additional language to that instruction. And next one, Ms. Hamilton.
That's all, Your Honor. Thank you.
Okay. And anything further with respect to the instructions that you believe needs to be placed on the record, Ms. Blodgett?
Nothing from the people, Your Honor.
All right, and so are we all set for the jurors to come in and deliver closing arguments?
We are, Your Honor.
Yes, Your Honor.
And will you be doing the closing
I will be
argument?
doing the
Okay,
closing.
so I don't want to call the wrong attorney again.
Appreciate that, Your Honor.
Okay. All right, so we'll have them come in for that.
And I'll leave the video screen, and they come in.
What do you think of that? Do the spotlight. I think it will.
All right, welcome back. You may be seated. That was a little bit longer than 15 minutes, but we did need that time to address some things off the record. So welcome back, and Mr. Becker, you may proceed with your closing argument.
Thank you, Eric. Second-degree murder. That's what this case is about. You've all been fully aware of this now. We've been paying attention, asking a lot of questions, but it comes down to a very important decision. Or does anything more important than this? A murder. Somebody died. And I hope we aren't getting calloused. And callousing is the fact that how many times do we watch a video of another person, Patrick, dying over and over and over again? It wasn't TV, it's not movies. This is a real man, a human being, who was shot in the back of the head back in April of 2022. We watch it over and over. He's got a family, he's got loved ones. So I hope we're not callous, it's just something we see because we somewhat get immune to somebody dying over and over and over again. And we try and take a rational kind of look at it. And I think the other thing, when you look at it, it's a serious crime, but it's got one of the more simple elements, if you will. Because it boils down to just a few elements. There's a lot of other crimes you're not aware of, but elements are what we have to prove beyond a reasonable doubt. And so when it starts off, we talked about over and over again, this is the first element. Patrick died because of a gunshot wound to the head that the defendant did to him. And so that the other part is, yes, this is also about him, about what he did. Because Patrick is no saint. I'm not going to sit here and argue Patrick was a saint. He was drunk driving. He was resisting. He was driving without a driver's license. None of those are executable offenses. There are ways to deal with it. It's just because he committed a felony. He could commit 20 felonies. He could have had other felonies. It doesn't mean he deserved to die or he has to die. That's for juries. That's for other things down the road. The other thing is, yeah, I'm not going to sit here and say he's a horrible person. Yeah, he's got a great family. We heard about how he's an All-American, grew up in Grand Rapids. Yeah, that's wonderful. That's great. It's also fairly irrelevant. Because you don't compare, okay, one's good, one's bad, we'll just throw it up there. You have to base the case based on the facts. You'll hear from the judge that sympathy or prejudice shouldn't play any role in your decision. So you've got to base your decision on the facts that were here, the facts that were what the witnesses said, the videos, all the policies and procedures. That's what you have to base it on. Not, well, he's a hometown boy and want to do good, and we've got this bad guy who's drunk driving. It's not that simple. It is simple in terms of the elements, though. Clearly, the defendant killed Patrick back in April. And he had an intent to do so. Because part of the instruction you hear, there's maybe 3 different states of mind. But I'm going to stop at the first one. There was an intent to kill. And the intent to kill, please don't get wrapped up. Nobody's saying that when we left that morning that he intended to kill somebody. When he fired the shot, he intended to kill. That is clear when you put a bullet in the back of somebody's head. So in terms of the elements they have to prove, the first 2 are proven, no question in your mind. Those are the 2. Those are the easy ones. So what does it come down to? Why are we here? Number 3. Number 3, was the killing justified or excused or reduced to a lesser crime? That is your decision. That is why you're here. And justified, I talked a little bit across the line clean. Words matter. And words matter in terms of, it matter, we're going to hear a lot of instructions, and sometimes jurors get wrapped up in terms of instructions that, this is the law, and we're in a courtroom, and somehow things change because you're in a courtroom. You lose your collective common sense, you'll hear that instruction from the judge. You have your own common sense, you have your experiences. The words that you use out there have the same meaning in here. Justified, done for a good and a legitimate reason. Excused, removing something you had to do. You're excused from school. You have a duty to go to school, you're excused from school, you're removed. So what is the duty here? You have a duty not to kill somebody unless it's a really darn good reason. That's the duty you have here. That's the duty any of us have here. There's no difference between a police officer or a civilian. You can't take a life without a darn good reason. So when you start looking at that, when you start getting into the evidence, I think there's maybe also a little bit of confusion in terms of the law. What is the law? Okay? What is the law, and the law impacting the policy? Because you heard that, there's, the policy of GRPD. You have to follow the law, okay? The judge will tell you, your job is to follow the law, policy, and what the policy is, in fact, may impact how you interpret the law and what happened here. But you have to follow the law. So the law on the left, the defendant must have honestly and reasonably, once again, words have meanings, honestly and reasonably. It can be two different things. You kind of think of the same thing, but you can have an honest belief, but it's not reasonable, right? There's a lot of people that believe, that have an honest belief. We never landed on the moon. It was a big hoax. Nobody landed on the moon. We made it up. There's a sound stage somewhere in California that we made up a moon landing. It's an honest belief. Is it reasonable? So a lot of what depends on is what is reasonable. And what is reasonable is also defined. And there's two, you'll see the same thing. You have the policy of GRPD is not vastly different from what the law is. You kind of take a look at the reasonable person under same or similar circumstances, looking at the totality of the circumstances, looking at everything that happened. What led up to that decision to fire that shot? You have to take in everything from the start to the finish. And it's got to be reasonable through the entire time. We've heard that testified to on a number of different occasions. So you have to, what is the reasonableness when you break it down? And once again, dealing with the facts of what was presented here today, or here this week, that the time you've been paying attention to. Well, maybe putting it another way, it was reasonable to shoot Patrick because he had the taser, he was outnumbered and exhausted. That's really the justification, that's the excuse, okay? And that's an important thing because it's not that he pointed the taser. Nobody said that. The defendant took the stand, can't say that in a statement, never said he pointed the taser at me. He simply had the taser. That's it. The best we could get at was, maybe he was starting to turn and he thought he may be pointing at him. No evidence, no evidence, never said he threatened it, said he was going to use it, that I was going to kill you, said anything like that. He simply had the taser as one of the justifications of why I had to shoot. And the other one is, he was exhausted and alone, outnumbered. So, kind of taking that second one, let's take a look at that second one going from that perspective. Okay, why? Why were we in that situation? Well, it goes back to the chase. There's no dispute that, the defendant had the absolute right to try and place him under arrest. Okay? He was driving without a license. And that's the thing you have to look at it. At the time, he knew driving without a license and had a bad plate. Those are the only two reasons. Okay? There's nothing else. Nothing else that the defendant knew at that point in time. So you have to take it at that point in time, that's what he knew. Didn't know about the drinking, that came up later. So at the time, he makes the decision to chase, and we're not going to play the videos, we've seen it ad nauseum, and that's a great thing now. You can go back in the jury room and play those. You can look at whatever you want, you have the ability to replay it, take different looks at it, pick whatever thing you want. Please, take a look at it, go over it. You paid attention, but now you get to really talk about it. So the decision to chase happens, and he makes the tackle. Okay? He makes the tackle on that, within a minute, that's when he's tired. He's exhausted and outnumbered. That's one of the first things he says in the statement. He's exhausted and outnumbered within a minute. Now, mind you, at 1 minute, this is one of the best fit officers in the Grand Rapids Police Department. And he's exhausted and tired within a minute? Well, apparently they should never chase anybody then, if that's the circumstances. And we're not saying, though, that police can never chase anybody. It's based on the totality of the facts and circumstances. And in this case, look at what's going on here. We talked about the use of force 9-1.5, relative size and stature, multiple subjects, relative strength, access to weapons. All those point against that decision to chase, right? Because from the get-go, he knew he gets out of the car, he knew he was bigger. We all, we heard from the testimony of Captain Cyber, well, he saw how he moved, got jumped off, kind of moved when he spun. Got lifted off the ground. He was we didn't know if he had access to weapons. That's a scary thing because how many times over and over again did we hear about Grand Rapids Police talking about traffic stops, unknown traffic stops? You have to anticipate there are guns in the car. You have to anticipate that the people with the car in the car may have a weapon. But we have a person flying off chasing, not knowing about the guns, not knowing about there's another person, knowing this person's bigger and stronger, and yet doing that. But then using it to turn around and saying, well, I'm outnumbered and I'm exhausted because I chased somebody. That's troubling. That's troubling to use that as a justification from the get-go. There's plenty of policy, and that's what we talk over and over again, Exhibit 36. That's the one policy we see, a set out policy. If you're looking at policy, how does that impact the law? That policy says, hey, if somebody's armed and dangerous, you're perfectly fine in following behind, having a plan, not tackling. It's bad tactics to tackle. And I thought it was ironic that, in terms we brought that up, that the defense then brings up, well, they're trained to chase. And they have to go over chases, but the chase that they talk about in Exhibit 31, they bring it up, you're responding to a system of foot pursuit. Solo officer gave his last location and no further updates. You're first on the scene to assist. And what does that talk about? The officer's in trouble. The solo officer's in trouble, and so you've got to assist this officer in, he got himself bit off more than he could chew, which is essentially what happened here. So yeah, they train and you can chase, but basically you don't go running off. Von Queen says, yeah, I'm not going to advocate somebody go running off and chasing people down a dark alley. You're outnumbered, there's no business. When you don't know the situation, call for backup and do that. But now they try and use that as justification of why this all happened. The next part, the next major part, is the taser. You grab the taser. Okay? And these are screenshots. These are some frozen screenshots from the frame-by-frame video that you have an opportunity to take a look at. When you look at the frame-by-frame, this right here, the one on the left is, you can see the taser, that's when the moment the taser comes out. This is a little bit further behind because it's just about to be deployed, because you see the two dots on here from Nick Bloomfield in terms of that's where the shots are going to go at that point in time. So when the grabbing of it during this period of time, what's going on? Why would you make it? And Nick Bloomfield's the one that says, well, yeah, you can use a taser, but you got a whole big issue with weapons retention right here. And you see why. You see why is because that's exactly what happened. He grabbed onto it. He grabbed onto it right then because he's face to face. But once again, you get back up. It's not like you're just looking at the silos. What did we talk about before? What did we talk about the criteria, if you will? Patrick's still stronger. Patrick's still don't know if he's got weapons. You're still outnumbered at this point in time. You're actually sticking, you're trying to stick a gun where this guy who you just tackled, had two hands on, were on top of, gets up and walks away, and now you're trying to hold on to him with one hand, and then deploying the taser at the same time, and that's gonna be a good idea. And so this is, we had experts, and this is Mr. Bloomfield saying, yeah, that's not a good idea. And you kind of see why that happened, but it also, once again, talks about policy going against, what does Taser say? This is from the PowerPoint. We go over the PowerPoint. Here's what Taser says about it, is that, employ other force options or disengage. Okay? So, Patrick did a bunch of dumb, bad things, but that, the defendant did some things that led to this firing a shot, and he's using those as justifications. Well, this all happened, ergo, I get to use deadly force. And that's where you get into Professor Stoughton and Nick Bloomfield. They're the ones, they don't disagree with everything that happened here. Yeah, you can get pulled over. Yeah, he had a right to arrest. But in these certain critical areas, there are critical mistakes that occurred here that a reasonable officer, not using 2020, a reasonable officer wouldn't have made those same decisions. You don't try and chase somebody that's bigger and stronger. You don't try and bring a taser out holding on to with one hand in a position where he can grab the weapon, especially when taser says, yeah, you can disengage. And the ideal footage that somebody has to use for a taser is 4 feet, even with the closed cartridges. Because we went over that. A closed cartridge, yeah, this Taser 7 had the ability to use closed cartridge, but closed is 4 feet, not an arm's length, which led to all this. So looking at the totality of the circumstances, you justify, well, I used a taser, I chased somebody, so I had to use, and I shouldn't have, but I had to kill him then. That's essentially what they're arguing. So one of the things you also have to look at is the imminent threat analysis. And this is kind of interesting because one of the things you hear in terms of all the witnesses, the experts on both sides, Von Queen and Professor Stoughton on both sides, they kind of use the same analysis, right? They talked about this. The imminent threat means intent, opportunity. Okay? I think there's a motive. I think Von Queen had motive. There's a similar thing. So if you think about that, when does Patrick move into a threat? When does it happen? Once again, you just don't, use the defendant's statement, because, okay, he didn't testify to this, but take a look at his statements. Those are exhibits 39, 38, 39, the last two things I just admitted. Because when you go back and I cross-examined on him, in terms of what did he think was going on, what was going on at the time, Patrick's trying to get away. Because these are his statements. He began to walk away, he proceeded to turn away, he ran away from the stop, he would not comply with commands and continue. That's, I think the last two are the key, continue to move his arms and legs in an attempt to get away. From the get-go, all this time before the taser grab, he's got the idea, yeah, Patrick's trying to get away. That's the defendant's perspective. That's what he says in his statement back in April of 2022. Okay, Patrick's not threatening me, Patrick's not taking a swing at me, Patrick's trying to get away. That's the whole basis. Even when it comes to the taser. And that's the thing, that's the key moment, okay? That's maybe that's where the, okay, something more's happening here. He puts his hand on the taser. What is the defendant's impression? The defendant's impression is he moved it so he'd not be struck. And that also compares when you think about, you start comparing, you compare the witnesses. What do the other witnesses say? What does Wayne Butler, the neighbor? Wayne says from the get-go, yeah, Patrick's trying to get away. Wayne says, yeah, he's trying not to get tased. That's the whole thing. That's not an expert. That's just a normal civilian. A neighbor sitting there watching everything. He's not trying to get tased. You can tell that. That's a lot of what Seth and Professor Stoughton and Nick talk about. There's an intent to flee. There's no intent to harm. There's no assault going on here. He's trying to get away. You don't get to shoot somebody because they're trying to get away. That's not a justification. That's not an excuse. That's what the law is. And that's what the impression of everybody here, including the defendant, because that's a statement. So when you start looking at it, has the ability to have an intent to do great bodily harm. That's the imminent threat analysis. When does that start? Well, is it here? Because once again, you get to look at the pictures now, because right here, clearly, that one on the far side, he's moving away from him. That's obvious to everybody. So why now, just because he's got his hand on the taser, is he going to use it against him? He's never threatened him. He's never tried to swing at him. And you go back to these. Look at the first two. He's got plenty of opportunity, right? He's arm's length away. Both hands are open. Take a swing, punch, do something. It's grab the taser, get away from him. So once again, how does a reasonable officer in this situation think I'm going to die? When a guy who's done nothing more than keep trying to get away from you, to keep trying to walk away from this. How does a reasonable officer get that out of this? And then you go to, and these are exhibits from the body cam, or excuse me, the cell phone video. You hear about, Professor Stone and Nick talk about, their opinion, based on generally accepted police practices, was that a reasonable officer in this situation would not make the decision to fire. And what do they say? One of the reasons is, well, he was never in a good tactical, Patrick was never in a good tactical situation. And look at this. This is a good tactical situation when you're on the ground. He's on his back. Take a look at that. He's flat on his back with the taser at his side. Okay? He's not. And once again, what does Wayne say? Wayne kind of says the same thing. Wayne's not, once again, not an expert, saying he's winning. The defendant's winning, I think he said. There's nothing coming from Patrick. Okay? Right here, this is the one thing they point to. Right here, just before the shot was fired, his legs get lifted off. His legs get lifted off the ground, but within a little over 10 seconds, he's back on the ground. So you break it up. So until the taser's grabbed, we have the defendant saying, yep, he's trying to get away. What happened in the next minute, 10 seconds approximately, that would make a reasonable officer think he's going to die? What did Patrick do? What did he do? He grabbed onto the taser. That's the sole justification. He grabbed onto the taser. Didn't point, didn't threaten, didn't say anything else. Once again, didn't throw any punches, didn't do anything like that. So why is a reasonable officer going to think, and that's exactly what Professor Stoughton and Nick said, a reasonable officer wouldn't have come to that conclusion. Generally accepted police practices, and generally accepted police practices are Grand Rapids policy. Because we heard that from who? Captain Cyber and Captain Pierce, who basically said, we're CALIA certified. we're certified by CALEA, they give us, that's generally accepted police practices. That's, you have other agencies come in and take a look at things, and generally police practices, and that's what Professor Stoughton and Nick base their decision on, base their opinion on, when you take a look at all these facts and circumstances. Why would a reasonable officer think he's gonna die when somebody's simply trying to get away, never in a tactical situation by their opinion, and as well as the civilian witness who saw it at the same time? So it also comes into this part. I'm trying to play it, hopefully it works, as long as it never.
Let go of him. No, let him good, like you can talk to him.
Because that was one of the bases. That was the basis of Nick Bloomfield said, well, the other thing on top of it, the taser there was no neuromuscular incapacitation. That was not possible because right there, because that's the second. And Brian Child says, yep, there's a second deployment. So it's been deployed twice. There was no probes that were going to fire out at that point in time. So he couldn't been incapacitated. Well, they call it, David Blake saying, what the heck's going on? We need to, he doesn't hear anything, there's tunnel vision, there's, he's gonna skip things and miss things. And his explanation at this point in time is, well, he could have, been out of breath. Been out of breath, I mean, listen to it and watch. Drop the tape, and then he moves it away as well. There's plenty of knowledge that he knew exactly what would happen, but you also take a look at everything else. And you look at everything else, what happened there, what else? All these other things that he heard through this entire incident. Take a look once again at his statement. He heard everything. He heard the neighbor coming out of the house at the beginning. That's when the fight's still on. He heard that you didn't hear him, but that's still hearing, other units were on the way. He could not hear sirens later on. After the taser struggle, he knew that there were no sirens coming, that other cars were approaching. So he heard everything, and suddenly there's just one thing he misses, and that's on top of all the other perceptions he was making at that point in time. He saw, this is, he testified, here, he saw the red on the taser on what was happening. So when you look at all that, he was aware of anything, so suddenly this one thing he missed, that he wasn't aware that that taser had been deployed twice, so there was no chance of neuromuscular incapacitation. You have to ask yourself that. How is that possible? One thing, you just missed one thing out of everything he perceived. He perceived at the moment he fired the shot, in his statement, he says, yep, I checked the background, there's nothing there. So it's not like he says, I don't remember what happened. He says, yep, I was checking everything, I saw everything, I heard everything through this entire incident. So there's knowledge there that the taser was not able to be fired that would cause NMI. And the fact that it suddenly, maybe the NMI, that it could have caused pain, we heard over and over again. How many times did we hear from the various defense witnesses? Were you tased? Yeah, it was painful. It was painful as heck. It was burning, it was everything. Pain is not a reason to use deadly force. You can't use deadly force because you're going to be in pain. There's no instruction. You can use deadly force when you think you're going to be killed or you're going to be seriously injured. Pain is not part of that. Just because it's going to cause you a lot of pain. Burning the pain of 1,000 burning suns doesn't justify it. But they try and work that in now. And they try and add that in. And quite frankly, look at his statement. That was never the concern back when he wrote his statement back in April. The statement was he was afraid that he was going to get tased, there's going to be neuromuscular incapacitation, and then Patrick was going to grab his gun. It wasn't the taser that was causing the issue, it was the fact that he may get shot. So NMI set in, and so Patrick's going to grab his gun. Why would you think Patrick's going to grab his gun? Patrick never went for his gun. He testified, never touched his gun, never tried to go after his gun, never grabbed his gun. But that was the feeling at the time. Which also going into policy, if you're trying to determine what policies should have an impact, you heard over and over again, what was the policy in 2020? Exhaust all alternatives before firing. Now I thought that's kind of interesting in terms of what they talk about. They keep on saying, well, in terms of if you make the decision to use deadly force, does that mean you have to go back down? That's not nobody's arguing that. Like I said, it's, during one of the witnesses, if somebody comes out with a gun and points it at you, you don't have to try and use pressure points, right? Nobody's saying that. But when you're in terms of a struggle over that lasts a couple, 2-3 minutes, yeah, you got to try something else. Then what do we have here? we have arm strike, one arm strike, a bunch of knee strikes, taser gun. What does GRPD teach on this? Why are we going over that? 4 hours, they're recertified. That's where you take a look at the exhibits, all the training records. They are taught for every year, going over all the pressure points, all the different stunts, all the different strikes, all the different things that are used to try and get control over a person who's not willing to be arrested. You don't need to use all this stuff. You don't need to do stuns and takedowns and pressure points. You don't need to grab somebody by the side of the jaw if they're compliant, right? You only do that is when they're not compliant. None of them are used. Zero, not one. So what is the purpose of this policy that says exhaust reasonable alternatives when nothing happens? They don't use it, it's ignored, doesn't even try. Arm strike, kick, taser gun. That's all we have here. And then that's part of the policy we talk about, require a warning shot. Now they say, well, it doesn't make a whole lot of sense that maybe stop is enough. Maybe stop is, we don't say stop or shoot, but there's some sort of warning, so we kept on saying drop the taser, that's enough. That seems that once again flies in the face of the policy that says is a warning shot must be given, or a warning shot, warning must be given before firing the shot after you exhaust all reasonable alternatives. None of them were exhausted. There was no really warning. It was just a shot in the back of the head from a guy who was trying nothing more than to get away. There was no threat there. He wanted to get away. Whatever reason, he wanted to get away. We don't know why. We don't know why he made that decision. He was drunk. That could have played a role. But that didn't mean he should die on that day. So when you look at it, a lot of what we are basing on, yeah, it's two experts. Our two experts, Professor Stott and Nick Bloomfield. And they based it on generally accepted police practices. What would reasonable officers do under this situation? And when you look at it, they take a look at the whole thing. As you look at it, there's I think Professor Stott said, yeah, there's an imminent threat. A reasonable officer would think there's an imminent threat of somebody trying to get away, but that's very different than an imminent threat of somebody trying to kill or hurt or injure somebody. Those are two different things. And once again, that's also backed up when the one civilian who really saw everything here, Wayne Butler, he kind of said the same thing. There was no evidence that Patrick was trying to hurt or do anything. He was trying to get away. The primary act was resistance, an attempt to hit harm, and he didn't do harm. I think that's an important thing. There's a fight to the death, and that's why I showed those pictures. There's a fight to the death, and the most injured, you got maybe some redness on his wrist. You're gonna fight to the death, and they keep on talking about a fight. How is a fight? Once again, a fight is defined as throwing punches, doing something else. This was a wrestling match. The most I could say, all the witnesses said this was active aggression. Okay? He was pulling away, he was wrestling. The only thing we can say is, well, potentially, maybe, he could have. The defendant thought maybe he was going to turn and fire the taser. There was never a tactical advantage. That's what they said. Never a tactical advantage. So why would you think that you need to do it at the moment and fire that shot? Because what had happened over and over again. You saw Patrick try to get up once, defendant shoved it down. Patrick got up again. What did he do? He walked away. So this time when Patrick's trying to get up again, he gets shoved down. Watch the video. Take a look at that video. He gets shoved down again. He never got up, fully walked around the second time after they went to the ground on the taser. They were wrestling. Patrick went to get up. He was shoved on the ground, and that's when the fatal shot was fired. The defendant had tactical control. The defendant was on top of him the entire time. Why would you think you need to use deadly force under these circumstances? So what happens? If it's not reasonable, it's not lawful self-defense. That's the only thing that justifies it. That's the only way we get out of here without a verdict of guilty under these situations. There's not a reasonable officer that think that Patrick was trying to kill him based on what was here. So what does that mean? Defendant's guilty. This is a traffic stop. At the time the defendant knew what was going on. It was for a bad plate and no driver's license. What out of all this he didn't think he was going to die? He had his taser? That's not enough. He was tired. Yeah, he was tired. Everything great. You don't need to beat over the head that he was tired. He was tired because he put himself in that situation. no reasonable officer that would think he was gonna die based on the facts and circumstances here. So the verdict that you must come at the end is guilty of second degree murder, and that's what I asked you to return the verdict of such. Thank you.
All right, Mr. Bordolo?
Thank you, Your Honor.
Good morning, everyone. Thank you for your patience. The prosecutor is trying to make this case something it's not. You're here because you're going to judge my client, Christopher Schurr, on the decision of whether or not to use deadly force in a situation, on his decision and his belief that he was in fear of either great bodily harm or death. You are not here to judge the GRPD policy. You are not here to judge whether it was reasonable for him to chase Patrick Lyoya. You have to decide whether the prosecutor has proven beyond a reasonable doubt, whether Grand Rapids Police Department Officer Christopher Schurr had a reasonable fear of great bodily harm or death. That is the issue. And you must look at it as to at the moment of the threat. When Patrick Lyoya had the taser in his right hand, whether or not Christopher Schurr was reasonably in fear. And the prosecutor has failed miserably. I want you to look at just the case that the prosecutor put on. And I would submit to you, the prosecutor didn't even meet his burden in their case. You heard from a couple of Patrick Lyoya's friends about what occurred the night before leading up to the events. There was a night of drinking. Mr. Lyoya wakes up at 8 a.m., according to the witnesses who were there. He's with Aime Tuyasheme and David Bakuru. And the prosecutor put on evidence of how much everybody was drinking. That was the prosecutor's case. And that they got into a car. No one is suggesting that anybody should be executed because they're drinking and driving. That's absurd. And that's nothing to do with what happened here. Yes, he was drinking and driving. Is that a bad thing? Yes, but nobody's saying they deserve to be executed, and nothing like that happened. The issue is whether or not he was in fear after Patrick Lyoya later on took his taser. So what happened is they get into a car, and it has a license plate from a different car. That means that the license plate belonged to a totally different car. Mr. Lyoya and Mr. Tuyasheme and another person was dropped off so that person could take his kid to school, and then they drive around. They visit Mr. Lyoya's new apartment. They stop to reload on Budweiser, and they're driving around again. When, according to Mr. Tuyasheme, they hear a noise in the car, and they were driving around. They take a couple right turns. They stopped on Griggs Street in Grand Rapids. And then Mr. Lyoya quickly exits the car to see what's going on. According to Mr. Tuyasheme, he really wanted to hear what the noise was to try to figure out how maybe there was something wrong with the car. But at precisely that moment, in an incredible coincidence, that's when Officer Schurr had pulled him over. You can decide whether or not that was the case, whether or not that's even relevant. But Officer Schurr, it's irrefutable and undisputable, he had a valid reason to pull him over. The plates didn't match the car. He's a police officer, and that's his job. He's at work. It's 8 a.m. on Monday. That's his job. That's why he's pulling him over. And the prosecutor agrees it's a lawful stop. After getting out of the car, Officer Schurr gets alarmed. You can hear it in his voice. He orders him back in the car. 4 times, get back in the car, get back in the car. Why is he doing that? Because he's trained that if somebody jumps out of their car, that could be a problem. So he orders him back in the car, and Mr. Lyoya refuses. Officer Schurr doesn't know why. He doesn't know why he won't go back in the car, but he just approaches him. But he doesn't know anything about a broken down car, because did you hear Mr. Lyoya say anything about, hey, my car's not working? There's a funny noise. No. So we're talking about the knowledge and in the situation of the officer here. So what does he know? He just knows somebody jumped out of the car. Instead of answering lawful questions, which the officer is allowed to do, Mr. Lyoya decides to start questioning the officer. What'd I do wrong? And then Officer Schurr is asking questions at the same time. Neither are getting answers. Officer Schurr, he says, you have a license. What for? Do you have a license? For what? Do you have a license? What'd I do? Do you have a driver's license? Do you speak English? Because now he's wondering, maybe he doesn't understand what I'm saying. Mr. Lyoya answers that question, yes. Can I see your license? What did I do wrong? And then Officer Schurr just starts answering his questions. He tells him, well, the plate doesn't belong in the car. That's why I pulled you over. He's hoping to get an answer from Mr. Lyoya. Do you have a license or no? Do you have a driver's license? Yes. Where is it? It's in the car. Get it for me. What did I do wrong? The plate does not belong in the car. He answers his question again. Police officers are supposed to ask questions at a traffic stop. They're supposed to get your ID. That's what a traffic stop is. And that's what he's doing here. And if you want to see how Officer Schurr responds when somebody actually complies in the smallest amount of way, watch this interaction. Look at his body language. Listen to the tone of his voice. When Patrick Lyoya says, it's in the car, get it for me. Does he scream at him? No. He steps back, literally steps back, get it for me. So what follows after this is a series of decisions by both of them. Patrick Lyoya is making decisions. Officer Schurr is responding to those decisions and making decisions of his own based on his training as a police officer. He's doing his job. Patrick Lyoya decides to walk away from police. Why? We don't know. Officer Schurr is trained, though, that failure to comply, ask yourself why. There's not a lot of good reasons for doing what he did. So he's alarmed again. So he went from, get it for me, please, to, oh, here we go. He's walking away, so I have to go back up. He decides he's walked away, I'm going to have to arrest him. Why? Because as a police officer, he's committed a crime. And it's not his job to decide who gets set free and who gets arrested. His job is to arrest. He is on the street to detect crimes and arrest people for them. And it's committed right in his presence. He doesn't think, well, I'm not really going to arrest this guy today. That's not his job. So then you saw that Mr. Lyoya, after Officer Schurr lawfully went to arrest him, resisted arrest. And we can argue about all day whether he affirmatively punched him, but balling up your fist and throwing arms like this, I agree he didn't face up to him that many times, just a couple times. He shoves him, and then he decides to run. Why is he running? Officer Schurr doesn't know. He doesn't even know his name at this point. Officer Schurr does his job. He calls it in immediately. Gets on his walkie-talkie. All right, somebody's running, and he catches him. He's arresting him. Feet from the car. Why? Because he's a police officer, and that's his job. He's doing exactly what we expect him to do. He doesn't get to decide, well, I'm just going to let this person go. That's an option under his training, but he made the choice to pursue him. And Professor Stoughton agreed that the initial pursuit was fine. He's just mad that he disagrees with the fact that he didn't peel off once he got near on the other side of the car. And you saw that Patrick Lyoya continued to resist arrest. He lifts him off the ground. Why? Yeah, he's getting away. But Officer Schurr is not trained to figure out what the motive was for the fact that he's resisting arrest. He's just resisting arrest. He doesn't have time to ask him questions. Why? Please just stop. He's not answering anything that he's saying. He's telling him to stop. So Officer Schurr decides to use greater force because he's a police officer and that's how he's trained to handle it. Knee strikes, commands, open hand blows. You heard that they were open hand. So he's not trying to hurt him permanently. He's using his open hand. That's how he's trained. And obviously, they're not effective. He didn't take out a stick and hit him on the head or anything like that. He's trying to arrest him. That's why he's using intermediate force. He's trying to get him to command, to comply with within the bounds of his training. Then you see Patrick Lyoya, he decides to get up and walk across the lawn with the officer in tow. Officer Schurr doesn't know why, but it's not his idea to go that way. Who's in control of this situation? He gets up. He walks him across the yard. Intermediate force didn't work. You hear Mr. Lyoya yell, "Get the keys." Well, sure looks like he's developing a plan to get out of there. So Officer Schurr has decided, oh, he just wants to get in his car and go away, so I'll just let him go. No. It's his job to arrest people that are committing crimes. He can't just decide, well, I have to let him go now, because he's saying he just wants to get his keys and get out of here. The suspect doesn't get to decide when you get arrested. So he pulls out his taser. That's the next step up. It's perfect. Everybody agrees it's perfectly appropriate to use intermediate force here. Fires the taser. As everybody agrees, Mr. Lyoya grabs it and moves it to the side. That was Mr. Lyoya's decision. That wasn't the officer's. He didn't say grab the taser because he put it in front of him. This is not an affirmative act of aggression, reaching out. He grabbed it and he never let go. And he tries to get it from Chris. And look what the officer's decision here was. Did he pull out his gun? No. Did he go to deadly force here? No. He decides to physically try to get it back. He's got the taser in his possession. He won't let it go. And Patrick Lyoya decides he's not giving it back. The officer's yelling at him to drop the taser. Let go of the taser. And then the fight is on. They both want the taser. That's what they're fighting over. And Officer Schurr has a right to it, and Patrick Lyoya does not. And Officer Schurr did not use deadly force to get back the taser. That is not why we're here. They go to the ground, and the film goes in and out because Mr. Tuyashime I'm sorry, Your Honor, is there something wrong with the camera?
The screen went out for a moment. It's back on now.
Thank you. So you see this part of what's going on. They're both still trying to get it back. And you notice that there's a part where it starts in Mr. Lyoya's left hand. And then it's in his right hand. And 11 seconds go by. And you can't really see what happens. So we don't really know how Mr. Lyoya got it in his right hand, but we know it was in his right hand. And then you see Mr. Lyoya roll over onto his stomach. Just like previously by Mr. Butler's house. He started on his stomach, pulls his knees in, and gets up. And that's exactly what's going on here. The taser is now in his right hand. Officer Schurr is trying to get the taser back still, and he can't. It's been switched. He's got exclusive control of it. He's on his back, yes, but why is he on his back? Because he's trying to get the taser back. And then you see Officer Schurr still trying to get the taser back. He's over the top trying to get this thing back. And you can see on the exhibit that it is in Mr. Lyoya's right hand. Right there. These slides, half a second apart. Half a second. This is how quick this is happening. It's a literal split second. Patrick Lyoya has got it, holding it in his right hand. It appears from the video, it's consistent with the officer's testimony that he's holding it like a gun. It's clear in the video that it appears that Officer Schurr is being lifted up. Is he jumping up? No, he's being lifted up by Mr. Lyoya. And the angle is turning, consistent with the officer's testimony. And here, this is no longer about arrest. This is the decision you have to judge. Whether in the moment of the threat, he was afraid of that taser, incapacitation, or great bodily harm. Whether it was reasonable for him to make the decision he never wanted to make that morning. Christopher Schurr was at work, and he was faced with the toughest decision of his life in half a second. That's what you're judging. Whether it was reasonable in that split second for him to think that an officer could be in fear of the taser. Not whether, what did Patrick Lyoya intend to do with it? He's holding it like a gun, and he's getting up. He has no idea why Patrick Lyoya is fighting this hard, and he doesn't have time to figure it out. 3 years later, when you hear about his family and his friends, yes, maybe you can draw some conclusions about what he was actually thinking. But he doesn't have the luxury. He's got half a second to make up his mind. And at this point, Mr. Lyoya has given him absolutely no reason whatsoever for him to believe he's not going to use it to get away. It doesn't matter why he's got it held like a trigger. I mean, if he's just trying to get away, he's still going to disable the officer to get away. So here we are in a criminal trial. And so now you're asked to judge not what the best practice was, but whether or not in the moment of the threat, whether the prosecutor, with his burden, proved to you beyond reasonable doubt, all reasonable doubt, that he wasn't in fear. And to help you decide this issue, the prosecutor brought in some experts. You heard from Mr. Childs, Professor Stoughton, Mr. Bloomfield, because he is trying to prove to you beyond a reasonable doubt that it was unreasonable for Christopher Schurr to be in fear. Beyond a reasonable doubt. And you heard from Mr. Childs, he works at Axon. It's the company that makes the taser. So he is an expert in tasers. A taser is a weapon, that's how they refer to it, and it's something to fear. The taser can cause incapacitation, even if the probes are discharged. If used improperly, a taser can blind or possibly even kill you. Probes can be reactivated once fired if they're lying on the ground. All you do is hit the button again. The wires can cause, even with wires, they can cause NMI, this incapacitation. They're insulated, but it's not a big insulation. It can get scraped off, especially if they're being dragged across the ground. The very next witness is Professor Stoughton. And followed him as Mr. Bloomfield. They wrote a joint report. And they've never heard of Brian Childs. Not really sure who he is. Didn't consider his opinions about the taser. How is that possible? They just flew in, gave their opinion, and flew out. It was their opinion. It's reasonable to use deadly force if going to be incapacitated. So they agreed. If you're going to be incapacitated and you're a police officer, you can use deadly force. It's reasonable to use deadly force if you're going to suffer great bodily harm. You don't have to lose an eye before using deadly force. That's what that means. But then here's where it differs. No objectively reasonable officer could be in fear of incapacitation from the taser because no reasonable officer could have feared incapacitation or great bodily harm in this particular situation. In other words, the taser is not dangerous in this situation. So you heard from Brian Childs, and then you heard from Professor Stoughton and Mr. Bloomfield. And they completely disagree with the prosecutor's own expert on tasers. They say a taser is not a weapon or something to fear in this situation. The taser cannot cause incapacitation if both probes are discharged. It's unreasonable to think the probes can be reactivated after being fired. Wires cannot cause incapacitation if insulated, because it's so unlikely. The taser is about as dangerous as a thumb in your eye. And even Mr. Bloomfield admitted, unless you're holding it like a gun. So you have the prosecution's own experts disagree with each other. You know what this picture is right here? That's reasonable doubt. You don't have to go any further. They're disagreeing with each other on the basis for why he should or should not be in fear. How can you convict someone for acting unreasonably and not being in fear when their own experts disagree? And certainly not beyond a reasonable doubt. Now, Mr. Stoughton and Bloomfield offer some more opinions. They admit they don't know how he's trained. And they essentially admit that there's no bearing on the ultimate issue of whether he reasonably could use deadly force. But it has no bearing. These other opinions about the chase and the staying too close. Why are we discussing this? You're asked to determine whether or not the prosecution has proved beyond a reasonable doubt that he was in fear at the moment of the threat, and then whether it was reasonable. Why are we talking about GRPD chase policy? Because they're trying to distract you from the actual issue. And even if you consider it, I mean, it doesn't matter if he chased him improperly. It doesn't matter if he's within 4 feet or 7 feet. And it doesn't matter if he used a compound sentence in his warning or is just a directive. The issue is reasonable fear. And that's why you saw all this evidence about tasers and this training. They just don't agree with each other. You don't have to go any further. The prosecutor is also suggesting that you should just let him get away. Let him go. He hadn't punched him. That's the standard for when you get to use deadly force? Well, up to now, I know he just took my taser, he's holding it in his right hand, but he hadn't punched me yet. So therefore, no reasonable officer would think that he was going to use the taser on him. None. That's what they're saying. That's what Professor Stoughton said. It's absurd. Not one officer, no reasonable officer. That's what he's saying. No one could think they were in fear. No one could think that he might use it on them. He's got to figure out that he's got some innocent motive for taking the taser from him after getting up 3 times before. Watch the video. If this issue, does he run away once the taser comes out, or does he turn around and grab it? Does he deflect it, or does he hold on? If it's just a reflex, oh, I don't want to get tased, you just deflect it. Does he ever say, hey, don't tase me? Does he throw it away once he has it? Does he listen to anything Officer Schurr is begging him to do? Is it transferred from his left to right hand? Why would any reasonable officer think he was going to walk away politely? In the split second that Chris had to decide whether or not he poses an imminent threat, all he knows is he's fighting to retain control. He knows he's lost the taser. He knows that he's turning and rising. His fear is unreasonable? No reasonable officer could think that. You should find him not guilty after the government's case. And even though we're under no obligation to put on evidence, because his entire life is on the line, we put on substantial evidence that the prosecutor cannot show that his fear was unreasonable. And we're constantly hitting these shifting arguments. You heard from the training officers, captains, Siver and McCursey. You saw a lot of training materials. Why is this relevant? Because you're considering the knowledge of the officer, not generally accepted police practices. They may coincide from time to time, but you're looking at what, he's a street cop. He's trained. Hours and hours of training. You saw a lot about taser training. Why are you seeing this? Because this is what's in his head of what happens when you get hit with a taser. I mean, is there any doubt that the training puts the fear of God in these guys about these tasers? They're weapons. You heard about firearms training, deadly force scenarios. One of you asked if they have implicit bias training. They do. This is a heavily trained department. And what is the point of all this training? Let me tell you about training. Officers are put in situations like this all the time, and you train because when you don't have time to make a reasoned decision with all the facts about everybody, you rely on your training. So when the time comes, you have to make a decision, you can act quickly. The same thing in military drills, sports, if you ever played sports, what do? You practice. So it comes almost automatic. When you don't have time to think in stressful situations, you rely on your training. All right, Captain Siver, he's a training officer, expert on GRPD policy and training. He testified that Officer Schurr trained on GRPD policies and trainings, not generally accepted police practices. Followed GRPD policy and training in the situation. Once a decision was made to use deadly force, He's not required to try other options. It's the decision to use deadly force. A reasonable officer in this situation could have used deadly force. Mr. Becker, question. That Captain Cyber didn't do an expert report. This does not matter at all. It's irrelevant whether or not he did an expert report. He was paid exactly $0. I know you heard a lot of paid experts. Captain Cyber isn't one of them. Captain McCursey. He's an expert in GRPD training and tasers. What did he tell you? Officer Schurr was given warnings that taser is a dangerous weapon. If someone gets your weapon, assume they're going to use it against you. A taser can incapacitate you and probe or drive stun. An officer does not have to wait before being harmed or killed before resorting to deadly force. And a reasonable GRPD officer in this situation could have used deadly force. He followed his training. The captains in the GRPD believe that he was reasonable in this situation. Now, let's talk about the prosecutor's experts on GRPD training. Here they are. None. So everything that involves his knowledge, you heard from the defense, and nothing from the prosecution. How did they show you he didn't follow his training? They didn't call a single GRPD officer. You know why he didn't call one? It's his burden to put on proof. Ask that question yourself. How else has the prosecution failed to meet its burden? We heard about exhaustion. Heard from Lombartel. It's reasonable for an officer in Schurr's position to lose ability to continue fighting. In a fight, you lose ability to contract muscles within 30 seconds. He was in a position of tactical disadvantage, not advantage. He fought with him for 2.5 minutes with a man that was larger than him. He's got nothing less, and he lost control of his taser. Or from Dr. Kroll, he wins the award for the smartest witness. He's a biomedical scientist. Why are we calling him? Because we're trying to refute this testimony by Professor Stoughton, who is not a taser expert, that you can't be incapacitated by this thing. So if you think that Professor Stoughton actually knows more than Mr. Childs, we called another expert. Drive stun can temporarily incapacitate you through disorientation. You have the probes, and then you have the drive stun. A scientist came and told you, yes, you can be temporarily incapacitated. And Professor Stoughton agrees, if you can be incapacitated and you're in fear of incapacitation, you can use deadly force. The drive stun can and has caused great bodily harm to sensitive areas. You heard this whole thing from Professor Stoughton. There's no reported deaths of police officers who lost their tasers as officers trained after they lost their tasers where someone took their gun and killed them. And you know why? You also heard that answer from Dr. Kroll. Because officers are trained to use deadly force if someone gets your taser. That's why. He told you how many deaths there were. You heard from Dave Blake. Well, you first heard from Mr. Bloomfield that this is not the type of situation where auditory exclusion and tunnel vision or this sort of closing in, it's not stressful enough. And then he was asked, are you an expert in human factors? Well, no. Well, this is Dave Blake, he is. He said this is exactly the type of case where this could occur. And that Chris did not have time to give a warning. That's it. That's how much time he's got to make up his mind. That's what you're judging him on. And this That decision, not whether he chased him a minute and a half before. That's how much time he's got to decide, and whether that was reasonable under those circumstances. The prosecution suggests that you shouldn't credit Dr. Blake's testimony because he went to an online school. But yet, he wants you to credit Mr. Bloomfield's testimony, even though he didn't go to school for this. I'll let you decide who's more credible. So you heard from the use of force experts. They pretty much agree on a lot of stuff. We agree on the standard as trained. When you're in fear of great bodily harm or death, that means they can't get you're not worried about a paper cut. It's got to be like stabbing, breaking a bone, or losing an eye. And of course, death. Then if the prosecutor could show beyond a reasonable doubt that he wasn't in fear at that moment, that's the standard. You heard about the totality of circumstances. And you can go through these. These are the things you're supposed to consider when reviewing whether or not the decision to use deadly force was appropriate. And we agree that a lot of these things applied. But that doesn't mean he shouldn't have tried to arrest him in the first place. This just means, under the totality of circumstances, the decision to use deadly force was reasonable. You know what's not on there? Foot chases. Because it doesn't matter. It's the decision to use deadly force that you have to consider. And he was bigger than him. There were multiple people. He was stronger than him. He got his taser. He's in a bad tactical position, or if you believe Professor Stoughton, he's in a better tactical position. The fitness level, the exhaustion, it's raining. He's getting up with the taser in his hand, and he's right next to him. All these factors point to a positive decision to use deadly force. You heard from Officer Gady. He's a firearms instructor. It's deadly force is deadly force. All the experts agree on this. It's the decision to use deadly force that you're judging, not the location of the shot. Not one expert said, oh, you have to try to wing him or hit him in the hand or hit him in the side. That is not what these experts are saying. It's the decision. Am I in fear of imminent is there an imminent threat? Then I can use deadly force. The manner of deadly force doesn't matter, and everybody agrees to that. Where do they disagree? Well, you heard that the prosecutor's taser expert and the prosecutor's use of force experts disagree. And you also heard that their use of force experts didn't really rely on GRPD policies and Michigan law. Instead, they have this generally accepted police practices. And that's because Professor Stoughton and Mr. Bloomfield, they're viewing this in hindsight, and everybody agrees you shouldn't do that. It's a sort of a woulda, coulda, shoulda thing. If you go back in the jury room and say, you know, if he just had let him go, that is not the proper analysis. I wish he just, I guarantee Christopher Schurr wishes, in hindsight, that he had let him go. He didn't want to make this decision. But that's exactly what the prosecution is doing here. Monday morning quarterback, based on all kinds of issues that don't matter, it's the moment of the threat. Look at his training, his knowledge, what he knew. And you take that into that situation, and you decide that based on what was in his head, the decision to use deadly force was reasonable. In this case, they have to prove beyond a reasonable doubt that it was unreasonable. Now, you heard Chris testify. He had no obligation to testify. It's a criminal case. What did he tell you? He testified about his knowledge, his training and experience. He was exhausted, running on fumes. He was alone. He called it in right away, but there's nobody there. You can listen to the video. Do you hear any sirens at the moment of the threat? Listen to it. Crickets. Where is everybody? He testified he did everything he could to avoid using deadly force. He didn't pull out his gun as soon as he grabbed the taser. Probably could have under this training. What, he tried to get it back. And he's screaming at the guy, let go of the taser. It's the moment of the threat. He testified that he saw the firearm. Let's get that. In his hand. He was trying to he testified he tried to put the safety on, even. Couldn't do it. He's in a bad position. He does not feel like he's safe. He's pulling himself up again, and look at what Mr. Lyoya had done 3 times prior. Literally lifted him off the ground, and now this time he's got the taser. It's reasonable for an officer to think in that situation that he's going to use it on him. It would be unreasonable for him to think he wasn't. But when he's given a chance, he comes into the stand to cross-examine him as vigorously as he did Captain Cyber. He barely even asks him about the moment of the threat. What is he asking about? You didn't have to chase him, right? That's the questions they got. You stand too close to him. You're in really good shape, aren't you? That's just designed to mislead you from the issue that is why you're here. He suggests that he's lying about the second pop because he said, look at the statement. Did he ask him about hearing it? Nope. He just wants you to look at a statement that was done. As Christopher Schurr testified, I kind of wrote it like a police report after seeing the video. I mean, this video was out there right away. That wasn't his fault. And then you have the state police asking for a statement, and he's got counsel already. And he signed it, so it's attributable to him. But keep that in mind. View the actual evidence, the testimony. The prosecutor has a chance to ask him all these questions. Now he asks you to answer based solely on a statement that was written with the help of lawyers a few weeks after the incident. That's not fair. He didn't have to testify, he did, and then he didn't ask him any questions. How can you assess his credibility on these issues when he wouldn't even ask the questions? All you're left with was what he said originally, but it wasn't the focus of cross-examination. No, it's something he wrote kind of like a police report because he's a police officer. And look at this exhibit right here. If you're wondering whether he's exhausted, I know he's in good shape, but 2.5 minutes trying to wrangle a grown man, desperately trying to get a taser back, is not the same thing as running on a treadmill. So you're going to hear about the law, and I think I have already stated over and over again what the issue is. Nowhere in here will it say, please consider whether or not Officer Schurr's complied with policy. Nowhere in it will say, hey, maybe we should change GRPD's foot policy. Please give us your thoughts on that. No. That's a distraction. Go to the next one. The relevant consideration is not what defendants should have known or done, but rather what a reasonable officer with the knowledge and the situation of the arresting officer could have believed at the moment the officer made the decision to use deadly force. That's why we're here. Professor Stoughton and Mr. Bloomfield say it's There was no reasonable officer could have thought he was in fear. We don't think the prosecutors come close to meeting that burden. If you start discussing whether or not GRPD should have a foot pursuit policy, stop, because that's not relevant. Look at the moment of the decision. It's the decision. Please, just look at this decision and whether or not there is enough there for any reasonable officer to think he might be in fear of harm. You're going to hear also that police officers do not have a duty to retreat. And this is important because private citizens do. Like if he wasn't a police officer and you saw this, then yeah, he put himself in a position he shouldn't be in. But Officer Schurr, he's not supposed to be retreating. He doesn't have a duty to retreat because he's a police officer. He put himself in danger, yes, because that's his job. You heard from one of the officers about the cowardice policy, just letting people go. You have to be sure that he wasn't in fear of great bodily harm or death before you can convict him of murder. Now, we go to the next one, please. Honestly, or go back, I'm sorry. Bob. One more. One more. It has to be an honest and reasonable belief. But you heard from Officer Schurr. Judge him on his testimony. And judge him, his testimony in comparison to what you saw in evidence from the video. You heard him say that Mr. Lyoya had exclusive control of the taser, and he did. You heard him say that he was completely exhausted after a minute, and you saw how he was 4 minutes after. And if there's any question whether he feared that taser, whether he had an honest belief, if he doesn't fear it, ask yourself, why is he trying to get it back? What is he, even after the second discharge? Does he stop for a second and slow down after that second probe goes? No, he's still going gangbusters trying to get it back. Why would you turn the safety on if it's as dangerous as a thumb? It doesn't matter what Professor Stoughton thinks about thumbs and tasers. It matters what he thinks. And look at the video. Does he slow down for a second? He's fighting as hard as he can to get that thing back. He's going over the top of him. He's putting himself at harm. Yes, because he's trying to get it back. Reasonable? This is what the prosecutor thinks is reasonable. No reasonable officer could have thought that that taser, with the probes discharged, could harm him, could incapacitate him. None, not one. These guys who didn't even talk to the taser expert for the prosecution, who disagrees with that completely. If no reasonable officer could have been in harm or thought he could be incapacitated, then why does everybody else that's called to the stand think you could, including taser experts? Especially when handled by an untrained person. Now you're going to hear a separate jury instruction on manslaughter. It's the first time you're hearing this. This is the prosecution recognizing this case is weak. It's a lesser included. It's for cases where someone didn't intend to shoot the gun. Officer, he got up there and he told you, yeah, I intended to use deadly force. I intended to shoot him. But it was justified because he had the taser and I was in fear. This is not a situation where someone gets in a fight and they don't really intend to kill him, but they lose their cool in the heat of passion before they have time to cool off. they kill someone and didn't really intend it. That's a lesser included. That's not this case. And justification of self-defense is a defense to both of them. So if you find that the prosecutor hasn't met his burden to show that he was unreasonably in fear, then you must acquit to both of them. You absolutely cannot convict him of murder or manslaughter if you acquit him of murder. Now, you've heard a lot about the burden of proof. And it's important. It's a criminal case, it's not a civil case. I think a lot of you were asked during the voir dire whether, it's got to be one of the, it's one of the most important decisions in your life, like buying a house. I agree. It's got to be, this decision is as important as those. And this is the highest burden under the law. I like to equate it to, you have a friend, family member who's on life support, and you have to decide whether or not to take them off life support. That's how important this decision is. It's any reasonable doubt. Now, the wiggle room in there is if it's not reasonable. If it's an unreasonable doubt, then that's not something you should consider. It has to be a reasonable doubt. If you have any sliver of reasonable doubt, then you must acquit. They have to prove beyond a reasonable doubt that he wasn't in fear and that his use of deadly force was unreasonable. If you're back to saying, well, he might have been justified, you must acquit. He could have been justified. Not sure whether he acted reasonably or not. That's an acquittal. That's the burden the prosecutor has to show before this is murder. And we just ask that you judge him on the decision and not all this noise around it. It's the split second. Any reasonable officer? This isn't murder. What an impossible decision. Make up your mind. It's not murder. It's not manslaughter. This man did not commit a crime. No one is saying Patrick Lyoya deserved to die. That is not what this is about. It's about, in the decision that we've asked Christopher Schurr to make, in that moment where he's supposed to be, whether the prosecutor's shown beyond a reasonable doubt that it was unreasonable. No reasonable officer could have used deadly force in that situation. That's the standard. And their experts don't even agree on what's dangerous. You must acquit him of both charges. Thank you.
Do you have rebuttal?
I do, Your Honor.
Okay. You may go ahead.
Agree. So you have attack prosecution's experts. That's one of the things you gotta take a look at. You gotta take a look at the credibility of witnesses. This is one of the instructions you're gonna get. Does a witness have any bias, prejudice, or personal interest on how a case is decided? And that includes the experts. That includes everybody here. So you want to compare experts here. Let's compare for science. For science is not an expert entity. For science is an advocacy group for police officers. That's what they're there for. Bond cleaning, and that's their network. That's their whole thing. So you want to compare about why not to believe somebody. Why would you believe an entity that starts out with giving the benefit of the doubt to the officer? That was Von Kleem's testimony. He starts out. So how can you be impartial? How can you be coming from a position of neutrality when you start out, you're gonna give the benefit of the doubt to the police officer? Which goes into them finding 98% of the time officers acted appropriately. What other profession is that infallible? What other profession? Name one that they're correct 98% of the time. So that goes into, how do you believe they're experts? Yeah, they parade a bunch of experts out here. And it gives you just an insight of what happened. If you guys remember my question to Mr. Bartel. I said, well, geez, you know, MMA goes 5 minutes, right? MMA goes 5 minutes. Well, that was the dumbest question ever made in the history of cross-examinations, because the disdain from the stand just oozed out of his pores. How could you can't compare an officer to an MMA fighter? MMA fighters train for 3 hours a day, so whole years, and blah blah blah. Yet, the next day, when Von Clean, his partner, his friend, who he presents with all the time, what does Von Clean do in his report? Compares Patrick to an MMA fighter. Because that's what they got to do. They've got to say the opportunity, he has an opportunity because he can spring up like an MMA fighter. That gives you a window in terms of the prism. They translate what happens based on an officer. They like officers, which is perfectly fine. I'm not saying that they shouldn't have advocacy groups for officers, but you judge an officer by one standard, then you judge the victim by another one. That's the opportunity. That was a tactical advantage because why? Because Von Clean and Lon Bartels do jiu-jitsu and they do grappling. And so ergo, that Patrick has the same opportunity because he can suddenly spring up from a face down or a face on his back position and maybe use the taser. That's what gives him the opportunity. Von Clean talks about, disproportionate resistance. That's their intent. That's his interpretation. That's what he said. Well, you can determine the intent. Disproportionate resistance by Patrick is why you can think he's gonna use deadly force. Von Clean doesn't want to use that against police officers because they have no idea how can they come up with disproportion. They can't comprehend that. So when you want to talk about bias and prejudice against the experts, you want to criticize ours, take a look at theirs. And then they're comparing apples and oranges. Because our experts are use of force, they say, in terms of taser, what a taser does, what a taser can do. And it's possible for these things to happen, but it's not reasonable to think it is going to happen. That's the reasonableness test. You can't look at every sort of possibility in the universe of what might happen and then say, oh, it's reasonable that you can do it. I mean, why does anybody take Wegovy? You listen to all the bad things that can happen on any of the drugs that are on TV because they may cause, hair loss, liver problems, and so on and so forth. But they want to use that as justification because all this may happen. It could, the wires could. There is no, talk about distractions. There is no evidence the wires were broken. There is no evidence that anybody was feeling MNI. There's no evidence that wires had any impact. But they got to throw out all these things. You want to talk about another thing? Why isn't GRPD? Why did we ask for GRPD? Does a bank, when somebody embezzles money, investigate their own? No, they call it an independent. They call it an outside organization. How hard is it? And this is not just GRPD, this is for anybody. How do you judge something that you trained? I mean, Captain Cybers said, I was his commander at one point in time. You think they're coming from a position of not bias because you're asking to judge their policies, their procedures, and what this person does? They like him. He's a good guy. How do you come in and say they're impartial? And once again, to give a window on that, what did Captain Cyber say? Because Captain Cyber, when we asked, we said, okay, you've been listed as a defense witness. Okay, what's the policy? If somebody's disarmed of a taser, do you have a policy on that? Nope. No policy. Never heard of it. Yet then he takes a stand in front of you and says, oh yeah, that's deadly force. Well, wait a second. 2 weeks ago when the detective asked you about it, you said, no, there's nothing. But now that, as soon as somebody disarms you of a weapon, that was a weapon. You never said taser specifically, but he was asked specifically about a taser and disarmament. Nope, there's no policy on that. We don't train nothing about that. But yet all of a sudden it changes. That gives you a window of why there's bias. There's a conflict of interest. That's why we have the state police in here talking about it. There's a conflict of interest to try and bring GRPD officers to judge on another GRPD shooting incident. They have every reason, just like anybody else. Just like a bank, you don't ask the people who were responsible for training what went wrong. But even that, and this is what I'm talking about, you can believe all, some, or none. They say Grand Rapids policies are generally accepted police practices. They're one and the same, there's no difference. Both of them say that. So to create this, he doesn't know what generally police practices are because he wasn't trained on them, it's just a fallacy because it's one and the same according to GRPD. But yeah, the other example is that, Officer Gady, why couldn't he talk to the officer? No, I got better things to do. He doesn't want to talk to an officer to give him, I'm not disputing. That's not a dispute. Yeah, when you use deadly force, that's what's trained. You use deadly force, you're going to shoot to kill. They're not going to try to shoot an arm off. They're not going to try to shoot a foot. That is, why do you want to talk to the detective about that? And so he trains, he was part of his recruit class. It's somebody in-house. You can't ask somebody in-house to be completely impartial and unbiased when you ask them to do stuff like that. But when you look at it, when you think about it, when you try and compare in terms of what's going on between these experts, compare the experts, what about Sergeant, I think it was Johnston, the first sergeant on the scene? Let's remember his testimony. Remember what he said? Did he or did he not sound like Seth Stoughton? Because he was worried. He said, yeah, we pulled up. I couldn't see inside that car. I didn't know what was going on in that car. I didn't know what the individual that was standing outside the car had. He could have a gun. That's what we teach. We don't know what's going on. I mean, that's the thing. He's got 3 officers at the time, all with handguns drawn. And look, watch the body cams. How carefully they approach that car because they don't know. That's what they're trained. So it's kind of a contradiction in terms of saying, yep, it's okay for a single officer all by himself to run after and chase and tackle somebody, which flies in the face of their policies that says don't do that you saw. That's a big difference there. How can you chase if they're treating everybody, 3 officers on scene, being that careful? Why is 1 officer all by himself? That's okay. That's fine. And so it's not distraction. So what is the purpose of the reasonableness of the officer's actions when you're looking at the totality of the circumstances? If it's just as many times as you snap your hands, there's no totality of circumstances. It's just looking at that moment, period, and what's the purpose of the totality of circumstances, looking how the officer got into that situation. There is no purpose. There is no totality of circumstances. Well, he was, somebody had a taser, you can shoot him. And the interesting thing was, because who did they say? Who did he say? Well, Professor Kroll is the one who said, oh yeah, they're able to use deadly force because he did that study. Professor Kroll isn't a taser expert. He has no idea of police policies. He said, that was his testimony, it was his impression of police policies. Because they can't bond clean, the GRPD officers, nobody can say anything about what the taser policy. There is no. Take a look at all the policies. Take a look at the policy where it says if you're just starting the taser, you can use it. You can shoot them. Because it's not there. There is no policy. It's based on the totality of the circumstances, based on everything the officer knew at the time. And what the officer knew at the time goes back to when the incident started. The whole thing, not just looking at that one brief second. And why would a reasonable officer, when there's been no aggression, there's been nothing, no punching, no kicking, no hitting, no anything, think he was going to die because somebody had his taser? That's what's not reasonable about all this. And you're right. You're right, manslaughter is going to be brought up. And it was a complete misstatement of the law to say, well, the manslaughter is not an intent to kill. That is not the law. Listen to the instruction. It is an intent to kill. The traditional manslaughter thing is when a spouse shows up and sees their spouse in bed and loses it. That's your typical manslaughter. You lose it and they want to kill them. It's not, well, they got into a fight. A manslaughter instruction is because of emotional excitement. Because of emotional excitement, somebody who's driven to kill somebody. That's what we're talking about here. It is not just, well, there was a fight you didn't mean to. That's a completely different thing. Manslaughter, listen to it. And because of emotional excitement to the point a reasonable person may have acted in impulse. And if anything, that's what their experts are talking about. That's what their experts bring up. Yeah, Professor Blake. Yeah. Heuristics. And I said, heuristics. It's kind of, putting in layman's terms, that means jumping to conclusions. And that's it right there. He doesn't know why he's running, so he jumps to a conclusion. The defendant jumps to a conclusion, well, there must be something worse here. There must be something worse here, I'm gonna jump to a conclusion and think it's a bad thing. That reduces it, so it's justified, excused, it reduces it to a lesser crime. Manslaughter is a lesser crime, so if you think this fight, if you think this battle, if it's, you need to characterize it as a battle, because what it is a wrestling match. And that's in the totality of the facts and circumstances. How does somebody want to kill you when they don't do anything else before that? How do they want to kill you? What evidence do they want to kill you? He grabbed my taser, and I'm tired. That's not enough. That is not enough to justify taking another person's life. And watch the video. Yeah, take a look at the video. Yeah, he stands up 3 times, but at the moment he goes to push himself up, the defendant shoves him back down. He shoves him back down. He's got total control over this incident. So to think that he has to kill him at that moment is just wrong. It's not reasonable. Yeah, no reasonable officer would come up with that. Yeah, why? No idea why it's so far. Where's the fight? It's not a fight. It's a wrestling match. I thought the other thing that was, interesting about, GRPD puts the fear of God. Puts the fear of God about tasers. Yes. Watch that video. Watch the graduation video. This is the graduation video. So the fear of God, you put that's a serious weapon, but the fear of God in an instrument that you put the soundtrack to Top Gun to in the graduation video, and take a look. Get a closer look. Look at the smiles. Look at the smiles on all their faces. Yeah, they're kind of, somebody's going through it again. It's taking the ride. We're talking about taking the ride. Yeah, it's a serious weapon, but it's not a weapon that's going to cause death or great bodily injury. That's not putting the fear of God into them when you put it to the soundtrack of Top Gun. It's not putting the fear of God into them when you're sitting there smiling at them, smiling at somebody getting tased. It's something you're concerned about, sure. But this whole thing in terms of distractions, once again, it's amazing now, because now we're saying don't ignore the defendant's prior statement, ignore it, because it was just a police report. But we heard on the stand that we couldn't trust his testimony in the stand either. Why? Because, Mr. Dodge asked him, well, he's been 3 years. There's a lot going on in those 3 years. You've been through a lot of trauma. So you can't really believe his testimony by his own, attorneys asking him questions, but then you're also not supposed to pay attention to his written statement. So how do you determine what it is? You gotta take it. That's what the statement's there for. Compare what the differences are. Take a look what it is. Take a look. Where did the bladed stance come from? Because that's what it says in his written statement. Where's the bladed stance? Because we heard what the bladed stance was by Captain Siren. Somebody may have a gun. That was a bladed statement. No testimony to that. It was in his written statement. And then I didn't ask him questions. Well, show us the bladed stance. Well, it's a different perspective. You really can't see. So, what we're trying to do is trying to build up the danger of Patrick. Trying to build him up. He had a bladed stance. It was dangerous from the get-go. Well, then if it's dangerous from the get-go, why are you chasing him? And that's part of the totality of the circumstances. You think you may have a weapon, you shouldn't be chasing him. That's what GRPD policy says. It's a bad idea to do that. And you gotta take a look at everything that led up to the decision to fire that shot. And simply getting up is not enough with the taser. He has gotten up 3 prior times and has done nothing. Has done nothing other than try and get away. But you're supposed to jump to the conclusion, using heuristics, jumping to a conclusion that he's gonna kill you. That is not reasonable. It may reduce it, maybe it's manslaughter, but it doesn't excuse it. It doesn't say, yep, go on away. You did nothing wrong here. So when you're looking at everything, it's a big decision. But a reasonable doubt, you'll hear, I've talked about it before, a reasonable doubt is a fair, honest doubt. But it leaves you firmly convinced. Firmly convinced based on the evidence. Based on the evidence that's presented here. I think when you look at this, when you look at the facts, when you look at the evidence, you should be firmly convinced that there was a homicide here, there was a murder, it was second-degree murder, it was a death caused by the defendant, he intended to kill, and there is no justification for it. Simply having a taser with nothing more does not think, well, I'm gonna die. We've had all kinds of people up here saying, yeah, we survived, we got tased numerous times, Fine Clean got tased in the head, he's still talking about it, lasts about 30 seconds. And even in terms of you want to talk about reasonable, use their expert, use Professor Kroll. It's never happened in the history of policing. where an officer's been tased, disarmed his weapon, and killed. And it's his impression that's because they kill. But the one thing where he said is it's happened 9 times where a person's actually been tased, an officer's actually been tased, but in the other case, the majority of the time, nothing happens. But they want to, every possibility consider, you have to consider what's reasonable. You have a reasonable doubt that he committed the crime of homicide. At best, he committed the crime of manslaughter, but he is not justified. He is not excused. Patrick was not a threat. Patrick meant no harm. Patrick wanted to get away because he was drunk or whatever. But the only logical conclusion you have is you find him guilty. Thank you.
Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements, arguments, and any commentary are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, summary of any evidence, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think a witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You have heard that a lawyer talked to one of the witnesses. There's nothing wrong with this. A lawyer may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have heard from several expert witnesses. Zachary Batchelor has given you his opinion as an expert in the field of video technician and audiovisual analysis. Dr. Stephen Cole has given you his opinion as an expert in the field of forensic pathology. Brian Childs, who has given you his opinion as an expert in the field of taser and bodycam by Axon. Seth Stoughton, who has given you his opinion as an expert in the field of use of force and police practices. Nicholas Bloomfield, who has given you his opinion as an expert in the field of police practices and use of force. Captain David Siver, who has given you his opinion as an expert in the field of GRPD training policies and procedures. Captain Chad McCursey, who has given you his opinion as an expert in the field of GRPD training policies and practices regarding taser use of force and duties and functions. Lon Bartel, who has given you his opinion in the field of exercise, sports science, and exertion and exhaustion factors. Dr. Mark Kroll, who has given you his opinion in the field of operations and effects of electrical weapons. Bob McFarland, who has given you his opinion in the field of video analysis. Jason Getty, who has given you his opinion in the field of GRPD firearm training policies and practices. David Blake, who has given you his opinion in the field of human factor psychology and police practices. And Von Kleem, who has given you his opinion in the field of police practices, tactics, policy, and use of force. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they gave for their opinion and whether those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about the other evidence in the case. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. Facts can be proven by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proven by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You have heard evidence that before the trial a witness made a statement that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. The defendant, Christopher Schurr, is charged with the crime of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Patrick Lyoya. That is, that Mr. Lyoya died as a result of a gunshot wound from a gun fired by the defendant. Second, the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Mr. Lyoya, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, the killing was not justified, excused, or done under circumstances that reduce it to a lesser crime. The prosecutor must also prove beyond a reasonable doubt the crime occurred on or about April 4th, 2022 in Kent County. You may also consider whether the defendant is guilty of the less serious crime of voluntary manslaughter. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant caused the death of Patrick Lyoya, that is, that Mr. Lyoya died as a result of a gunshot wound fired from a gun by the defendant. Second, the defendant had one of these three states of mind. He intended to kill, or he intended to do great bodily harm to Mr. Lyoya, or he knowingly created a very high risk of death or great bodily harm, knowing that death or such harm would be the likely result of his actions. Third, the defendant caused the death without lawful excuse or justification. The crime of murder may be reduced to voluntary manslaughter if the defendant acted out of passion or anger brought about by adequate cause and before the defendant had reasonable time to calm down. For manslaughter, the following two things must be present. First, when the defendant acted, his thinking must be disturbed by emotional excitement to the point that a reasonable person might have acted on impulse without thinking twice from passion instead of judgment. This emotional excitement must have been the result of something that would cause a reasonable person to act rashly or on impulse. The law does not say what things are enough to do this. That is for you to decide. Second, the killing itself must result from this emotional excitement. The defendant must have acted before a reasonable time had passed to calm down and to return to reason. The law does not say how much time is needed. That is for you to decide. The test is whether a reasonable time passed under the circumstances of this case. The defendant's intent may be proven by what he said, what he did, how he did it, or by any other facts and circumstances and evidence. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon used, the type of wounds inflicted, the acts and words of the defendant, and any other circumstances surrounding the alleged killing. You may infer the defendant intended to kill if he used a dangerous weapon in a way that was likely to cause death. Likewise, you may infer the defendant intended the usual results that follow from the use of a dangerous weapon. A gun is a dangerous weapon. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. You may return a verdict of guilty of the alleged crime, guilty of a less serious crime, or not guilty. The defendant claims he acted in lawful self-defense. A person has the right to use force or even take a life to defend himself under certain circumstances. If a person acts in lawful self-defense, that person's actions are justified and he is not guilty. You should consider all the evidence and use the following rules to decide whether the defendant acted in lawful self-defense. Remember to judge the defendant's conduct according to how the circumstances appeared to him at the time he acted. At the time he acted, the defendant must have honestly and reasonably believed that he was in danger of being killed or seriously injured. If the defendant's belief was honest and reasonable, he could act immediately to defend himself, even if it turned out later he was wrong about how much danger he was in. In deciding if the defendant's belief was honest and reasonable, you should consider all the circumstances as they appeared to the defendant at the time. The relevant consideration is not what the defendant should have known or done, but rather what a reasonable officer with the knowledge and in the situation of the arresting officer could have believed at the moment the officer made the decision to use deadly force. Reasonable is that which an ordinary, prudent, and intelligent person with the knowledge and in the situation of the officer would have deemed necessary under the circumstances. A person may not kill or seriously injure another person just to protect himself against what seems like a threat of only minor injury. The defendant must have been afraid of death or serious physical injury. When you decide if the defendant was afraid of one or more of these, you should consider all the circumstances, the condition of the people involved, including their relative strength, whether the other person was armed with a dangerous weapon or had some other means of injuring the defendant, and the nature of the other person's threat. At the time he acted, the defendant must have honestly and reasonably believed that what he did was immediately necessary to prevent death or great bodily harm to himself or others. A police officer in defense of himself or others may use that force which is reasonable under the circumstances. Unlike the private citizen, a police officer, by the necessity of his duties, is not required to retreat before a display of force by his adversary. If an officer is authorized to arrest or detain someone and the person resists, the officer is entitled to use a reasonable amount of force to overcome that resistance. Like the private citizen, a police officer must reasonably believe himself to be in great danger and that his response was necessary to save himself from that danger. The defendant does not have to prove that he acted in self-defense. Instead, the prosecutor must prove beyond a reasonable doubt the defendant did not act in self-defense. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. When you go to the jury room to deliberate, you may now take your notes and these full instructions. If you want to look at any or all of the exhibits that have been admitted, just ask for them. When you go to the jury room, you will be provided with written copies of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing to my clerk. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my clerk. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. That concludes your final instructions. We'll now pick 2 individuals that will be alternate jurors. So what that means is for today, you are excused. However, you still have the same restrictions as before. I'm going to ask those 2 individuals to leave your notes in here on the chair, and we'll make sure they're destroyed in the event that you're not needed as an alternate juror. But it's still for you, again, to maintain the restrictions as before, not access any news reports or discuss the case with anyone, because if we need to call you back as a juror, obviously if you've been out posting on Facebook about how you were a juror and all that, then you wouldn't be much use as a juror in the case. So those 2 individuals will still be, again, under the same restrictions, and then we will follow up and let you know when a verdict has been reached, so that you know that you are discharged, whoever those 2 people are. And I'd also like to take this time to thank those 2 individuals for your time and attention for this case.
Seat number
Wait,
2,
so
120.
just because we're on, don't say the person's name, just say that the seat
Seat number 2, seat number 2.
yes. It's seat number 2?
Correct.
Okay. And so 1 and 2 would be you in the first 2 seats from the corner. And again, thank you very much for your time and attention, and we will let you know when a verdict has been reached, so that you know that you're discharged. But if you just hang out for just another moment, then we'll send everyone back. Okay, can you please raise your right hand? You do solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them, orally or otherwise, that you will not communicate with them or any of them orally or otherwise, except by the order of this court, or to ask them if they have agreed on their verdict until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they've agreed upon, so help you God.
Yes, I do.
Thank you. All right, so at this time, I'm gonna have someone come out and let you all out to go and begin deliberations. Any breaks will be on your own. If you do decide to leave for an extended period, I do ask that you have your foreperson just write a note that, hey, we're taking an hour break or however long, but that's all entirely up to you as a group. Okay.
Thank you, you may be seated.
Okay, and then I'll ask if the final instructions were satisfactory for the people
No objection, Chair.
and defense.
Those objections already stated, Your Honor, they were read correctly.
Okay. And so I would just ask that you make sure that we have your contact information so that we can alert you if once a verdict has been reached. I also, because I know that you didn't want to do oral argument on these motions that I received this morning after I arrived at court, but I do want to rule on them. So as far as the directed verdict, I've already ruled on that motion. It's a renewed motion. There's really not any new information contained within it, so I'm maintaining my previous ruling of denying a motion for a directed verdict. Also, there was a renewed motion for a mistrial. And part of, I mean, it's pretty much a run-of-the-mill except for the claim of judicial bias. There's an allegation contained within the motion that I was rolling my eyes during some testimony. I can't help but believe if one of my benchmates were presiding over this trial, that exact same allegation would not have arisen. However, I obviously don't, well, maybe it's not obvious, but I'll state for the record that I don't know the defendant. I don't know the victim. I've done, this is at least my 10th, 11th, maybe 12th murder trial. I do oftentimes work on other matters while I'm up here. I have hundreds of open cases. So I really, I don't know where that implication of bias comes from. I do note that one of the cases that were cited as support for that portion of the motion involves a case where the judge in that case inappropriately questioned the defendant, questioned the defense's witnesses. I didn't obviously question anyone except for maybe asking for some type of clarification. And so it would have to, again, in order for there to be judicial bias, it'd have to be reasonably likely that my conduct is improperly influencing the jury, and I don't believe that to be the case. Also, there was a claim that the instructions have changed over the course of the trial. I've only given instructions to the jury at the outset of the trial and at the end of the trial, and the implication is that I gave some different instructions or changed them midstream so that no one knew kind of what to expect, but I don't believe that to be the case either. I've never changed instruction. It implies that different instructions were given. I was reluctant to state what the final instructions would be without any evidence being put on or presented. There weren't any interim instructions requested, so I don't believe that to be a appropriate or an argument that has any merit either. So for those reasons and the reasons I cited previously, that a mistrial, or most mistrial would not be appropriate to grant, I'm going to stand by that and deny that motion as well. And if there's nothing else for the people while we go into verdict watch
Nothing for us, Your Honor.
for defense.
Nothing, Your Honor.
All right, so again, if you do decide to leave the general area, please let us know so that we are able to get everyone back here in a decent amount of time, once a verdict has been reached. Great.
Thank you, Your Honor.
All right, and we'll recess until then.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free.